June is National Safety Month, which is a great time to be mindful of the different ways injury risk can pose itself and what to do if you find yourself injured. We're joined right now by attorneys Jeffrey Ward and Brandon Dawson with the Thumbs Up guys to talk all about it. Good morning to both of you.
Good morning, Emily. Thanks for having us.
Great to have you guys here. Happy June. First of all, I want to start out. If you trip, you slip, you fall, what's the first thing you should be doing before even calling a lawyer?
Yeah, before you even call us, make sure you report that injury. Go to the management, get an incident report. That way we know that it actually occurred at that location. They don't get to say, oh, it never happened here. Number two, if you're able to, please take pictures. Video is even better of what was there, because they a lot of times will destroy that and go, oh, we didn't know, what are you talking about? So incident report, pictures and video.
Awesome. Yeah. If you get into an accident on the road, the other driver says that we were partly at fault, can you still get compensation from that?
Yeah, absolutely. You know, you'll hear that a lot. Adjusters especially will try to put some of the blame on you, but even if you were up to 50% at fault, you can still recover. Now, your damages get reduced, cut in half, but we see it all the time. They try and say, well, you were 30% at fault, or you're 27% at fault, some random number. And, we do our investigation. We try to figure out, what really happened. And if we agree there's some fault on behalf of our client, we accept that, and, the damages get adjusted accordingly. But if we disagree, we either convince them of our position, or we just proceed with filing a lawsuit, because ultimately a jury decides percentage of fault, allocation of fault. But no, it does not bar a claim unless you are 51% at fault. That is the complete bar to recovery. But even if you're 50-50, you can still recover. Your damages might just be adjusted based on that percentage.
If someone gets injured at work and their employer says that injury is covered by workers' comp, is that the only option?
Not always. So depends on how the injury occurred. If there was a third party that was negligent, probably the easiest way to do this is if you're a delivery driver and you get rear-ended. That driver that hit you and caused the accident, you actually have what's called a third party claim. So you have your workers' comp claim that will continue on like normal, but you will also be able to bring a claim against the driver that caused your injuries. So you would then be able to ultimately file a lawsuit against that driver and have a recovery there. Now, the one caveat is you don't get the double dip, meaning that your workers' comp claim can subrogate or basically get back money from what you got out of the motor vehicle claim. There's ways to limit that. So that's where having a good attorney, we know how to limit what they're allowed to take. And what we do is we call it cramming down the lane. So a lot of different ways there, but yeah, it depends on how it works. Sometimes you're barred from recovery if you just slipped and fell at work and nobody else was at fault. Well, your only recovery avenue is going to be workers' comp. So give us a call. We look at every case to look, is there a products angle, is there a third party angle, or is this just solely a workers' comp claim?
Yeah, every case we have come in when it's a workers' comp, we always explore third-party liability as well. Another good example is, you're a delivery person and you get bit by someone's dog while making a delivery. That's a common third-party, claim as well. But juice just has to be worth the squeeze. We always look at it from all angles to make sure we maximize a recovery for somebody.
Awesome. Thank you guys so much for all of this, guys. Don't forget to go to inpain.com, or you can call that number on your screen if you have questions about any of today's topics. Thank you.
Thank you.
Thanks.